We're back. Hi. I took a little break. Took a little breather. What's up? I know. Everyone's diddied out, but calm down. We're going to review the documents. It'll be okay. We'll get through it pretty quick. Hey, what's up? I see Tipsy, Sarah, Debbie, Top Cat, Gala, and Stephanie. Hey. All right, so I'm a little behind on the Diddy stuff. I know. We're waiting for the result on Monday, but I am not caught up on the documents since the 18th. There's a couple of them, and we're going to review them. Hey, Peasy. Hey, I'm Clar. Yay, you made it. Oh my gosh, I need a drink of water. Sorry. Pause. Pause. Okay, I'm back. Hey, Chicken Nugget. What's up, Chicken Nugget? How you doing? Hi, beautiful Sarah. All right, let's get started. Diddy documents. Here we go. Hey, Johnny. Good to see you. All right, let's get it started on the diddler. Filed November 18th. Dear Judge Submaranian, I appreciate you guys for being here, by the way. Hey, Augie. Thank you for gifting on the last live. I appreciate you so much. Appreciate you, beautiful Sarah. Yes, Chicken Nugget. It's insane. That's why I want to cover it. I've almost covered all of them. I have one more Diddy live with older documents, and I'm caught up on all lawsuits. So we're going to get through it today. So let's get started. Filed November 18th, document number 7, Dear Judge Submaranian. Defense counsel, oh, sorry, let me zoom this in. Can you guys see that okay? Yeah. Yes, he did get caught. There's all kinds of stuff going on with Diddy. Let's get started. Defense counsel has recently learned that the prosecutors are in possession of attorney-client privilege material, including the defendant's own written notes. This search and seizure are in violation of Mr. Combs' 4th, 5th, and 6th Amendment rights. Moreover, the targeted seizure of a pretrial detainee's work product and privileged materials created in preparation for trial is outrageous government conduct amounting to a substantive due process violation. Because the prosecutors are currently in possession of privileged material and are actively using this material to detain the defendant, the defense requests an immediate evidentiary hearing. This is an emergent matter because the government has Mr. Combs' privilege notes to his lawyer concerning defense witnesses and defense strategies. The government's opposition to defendant's bail motion states that the trial prosecutors are currently in possession of quote unquote possibly privileged material such as notes recovered from the defendant's cell. In fact, the government is in possession of written material that is absolutely privileged. This is a matter of grave concern. Most respectfully must be addressed immediately for the following reasons. First, there's no dispute that the government is in possession of privileged material. Second, until receiving the government submission at 11:29 p.m. on Friday, November the 15th, the defense has never been told that Mr. Combs' notes were taken from his cell and that these notes were given to the U.S. Attorney's Office. And these notes were given to the trial prosecutors in the case, who then used this material in a filing to keep Mr. Combs detained. We request an immediate hearing on which the government shall provide answers to the following cases. First, who authorized a search of Mr. Combs' sleeping area, personal effects, and paperwork? Second, who determined what paperwork to take? Third, who decided to give this paperwork to the United States Attorney's Office? Fourth, who decided to give this paperwork to the trial prosecutors? And fifth, who made the decision to not tell Mr. Combs' counsel that U.S. Attorney was in possession of his notes, including possibly privileged materials, until after the government put them in a filing to keep him incarcerated? And number 6, exactly what material was taken. Because of the U.S. Attorney and it seems the trial prosecutors are currently in possession of privileged materials, we request a full evidentiary hearing as soon as the court can accommodate us. And that was Mark Agnifilo. Document 17. Hey, Travelin, good to see you. Appreciate you for being here. So that was document number 70. Some of them are just like 1 or 2 pages, so we'll get through them pretty quick. Document 17, also filed on November 18th. And this is, I'm going to pull it up. All right, here we go. November 18th. Oh, this is just that the government responded. The government must respond by 5 p.m. today, November 18th. The court will hold a hearing on November 19th at 3 p.m. We already saw that. So that's basically what that document states. We're just going through the docket here for the ones that I missed. Document 72. This one's a little bit longer. Also filed on November the 18th. Sorry, the way that I got them from the court, I have to put them up on a different screen. Okay, here we go. Dear Judge Submarinian, the government respectfully submits this letter in connection with the defendant's letter dated November 18th and in response to the court's issued earlier today. For the reason that followed, the relief requested by defendant, including an evidentiary hearing, are necessary. On or about September 16, 2024, the defendant was arrested. The following day, the above referenced indictment was unsealed and the defendant was presented arraigned before the Honorable 𝗏𝗏𝗃𝗏 United States Magistrate Judge. As part of the proceeding, the government moved for detention under the Bail Reform Act, finding that there was no condition of combination of conditions that would assure the safety of the community. The judge denied the defendant bail. The following day, the Honorable Andrew L. Carter heard the defendant's bail appeal and after a lengthy hearing, determined that the government had proven by clear and convincing evidence that the defendant was a danger to the community and a risk of obstruction. Since being ordered detained, the defendant has been held at the Metropolitan Detention Center, Brooklyn, a Bureau of Prisons facility. With respect to inmate communications, all BOP inmates, including the defendant, are afforded the opportunity to confer with attorneys on unmonitored phone lines. Other communications occur over BOP monitored phone lines and email. As part of its general practice to screen monitored communications for content that could jeopardize the public or the safety, security, or orderly operation of the facility. BOP staff, including a particular BOP investigator, Investigator 1, has consistently monitored the defendant's communication on monitored communication channel, including monitored phone lines. This monitoring is independent of the case team, and it is not done at its direction. As set out in the government's November 15, 2024 brief and made clear on record during the previous bail hearings, the government's grand jury investigation of the defendant, including the defendant's obstruction related to the criminal case, is continuing. As part of that investigation, the government has sent grand jury subpoenas and documents requested to the BOP for the defendant's monitored communications, including calls and emails. From those materials, the government has learned that the defendant has persisted in engaging obstructive conduct since he entered the BOP custody. Among other things, the defendant has engaged in unauthorized communication practices, including three-way calling on a monitored phone line, use of other inmates' phone access, PAC numbers to make phone calls on the monitored phone line, and 3, use of third-party text messaging provider through the BOP's monitored email system. Each of these methods of communication is prohibited by BOP. Furthermore, as set out in the government's November 15, 2024 brief, the defendant used these unauthorized methods of communication to continue to engage in obstruction, including by instructing third parties to reach out to witnesses and attempting to influence the jury pool in the criminal case. The defendant has used all 3 of the aforementioned methods of communication to communicate with his attorneys. Accordingly, although it is clear to all parties involved that these calls and emails are monitored in an abundance of caution, the government sent any potentially privileged communication, i.e. any communication involving an attorney, to the filter team for review before it was released to the case team. As is in the government's longstanding practice in ongoing covert investigations, such as investigation into the defendant's obstructive conduct in the MDC, the government did not disclose potentially privileged communications to defense counsel in the first instance. As stated in the government's opposition to the defendant's bail motion, the government intends to produce all the defendant calls and emails in full to defense counsel today. Sweep of the MDC. In and around October 28, 2024, the BOP and several other federal and local agencies initiated a sweep of the MDC. The sweep was pre-planned, coordinated to ensure the safety and security of staff and inmates at the MDC, and was part of a larger safety and security initiative and not in response to any particular threat or intelligence. The MDC sweep included the jail and the warehouse where MDC food and other property are stored. It was planned well in advance of the defendant's arrest and was not conducted to target any particular inmate, including the defendant. During the MDC sweep, multiple housing units were searched, including the defendant's unit. Although members of the case team were aware in advance that the defendant's housing unit would be searched, no one on the case team supervised, conducted, or participated in the search of any housing unit, nor the search of the defendant's bunk area. In fact, the case team was not aware in advance of what agents and officers were conducting the search of that housing area. Investigator 1 was assigned to BOP to participate in the week-long sweep and was present at the MDC during the operation. During the sweep of the defendant's housing unit, Investigator 1 interviewed multiple inmates, including the defendant, about potential corruption and contraband at the MDC. Following Investigator 1 interview of the defendant, Investigator 1 approached the defendant's assigned bunk to check for contraband. On the defendant's bunk, Investigator 1 found the following items. 1, a manila folder marked legal. 2, a notebook labeled redacted. 3, an address book and personal effects. Investigator 1 felt the outside of the manila folder marked legal for contraband, and feeling none, set it aside and did not open or photograph it. With respect to the notebook labeled redacted and the address book, Investigator 1 took the photos of these materials. Investigator 1 left the materials on the defendant's assigned bunk. No physical materials were seized from the defendant. Following the MDC sweep, Investigator 1 alerted the case team that he had taken photos of the defendant's redacted notebook and address. Investigator 1 described the blank notebook as largely notes to self written by the defendant that included notes regarding redacted. In an abundance of caution, the case team asked Investigator 1 to provide photographs directly to the filter team, given the possibility that they touched on legal strategy. Following review, the filter team provided certain of the photographs to the case team, including photographs containing redactions. Let me say hi to you guys. Hey, Stella, good to see you again. Thanks for being here. Sarah says, Diddy is wild as hell. He did so much damage. I know. This is a wild case. Let's continue. The instant motion. On November 8th, 2024, the defendant submitted a renewed motion for bail in front of Your Honor. In the government's response filed on November 15th, 2024, the government argued, among other things, that the court should deny the defendant's motion to reopen the bail hearing since he had failed to present any or new material information. In addition to the government argued that the defendant was actively continuing his efforts to obstruct justice while in custody, including, by among other things, attempting to influence witness testimony. In support, the government cited to exports of portions of the photographs that discussed defendant paying a potential witness and redacted on another potential victims and witnesses, which had been provided to the government after review by the government's filter team. Both experts are consistent with other evidence discussed in the government's submission. On November 18, 2024, defense counsel submitted a letter motion to the court arguing that the government was in possession of attorney-client privilege material, namely portions of the photographs which reflected the defendant's notes, which it argued were privileged notes to his lawyers concerning defense witnesses and defense strategies. The defense also argued that the government had engaged in a targeted seizure of the defendant's materials. At one, which it argued amounted to a violation of the defendant's constitutional rights. The defense therefore requested that the court hold a hearing to assess, among other things, who authorized a search of Mr. Combs' cell, determined which materials should be seized, and provided the materials to the government. A discussed herein, there was no targeted seizure of the defendant, and the BOP sweep resulting in the government obtaining photographs was not unconstitutional nor improper. In accordance with BOP policy, staff may search an inmate's housing and work area and personal items contained within those areas without notice to or prior approval from the inmate and without the inmate's presence. BOP program states, this is consistent with the law, which states that an inmate's reasonable expectation of privacy is extraordinarily circumscribed because of his interest in privacy must be balanced against the interest of society in the security of its penal institution. Although pretrial detainees like the defendant retain some Fourth Amendment protections, that does not mean that these rights are not subject to restrictions and limitations. Indeed, even when a prison regulation impinges on inmates' constitutional rights, the regulation is valid if it is reasonably related to legitimate penological interest. Accordingly, although pretrial detainees may have some residual privacy interests that are protected by the Fourth Amendment, courts must weigh these interests against the requirements of preservation of institutional security and order. Diddy is disgusting. He ruined so many lives and stolen people's childhood. He deserves a DP. I agree. I think he is outrageous, and it's been going on for way too long. Yeah, I never liked him. I did like his music, though. Let's move on. When potentially privileged materials are obtained by the government, the use of a filter team is common procedure in the district and has been deemed adequate in numerous cases to protect attorney-client communications. The government established an effective firewall to prevent disclosures to the government's trial attorneys of trial strategies or confidential communications between the defendant and their attorneys. Moreover, even if there was inadvertent disclosure of privileged material to the prosecution team, that alone does not suggest that a defendant's constitutional rights were violated or that a defendant is entitled to relief. The government's review need only be reasonable, not perfect. Give me one sec. Okay, let's move on. First, the fact that the photographs were taken was entirely proper. They were taken during a pre-planned sweep of MDC, which was organized, initiated, and executed by BOP staff with the assistance of multiple federal and local partners for the purpose of safety and security of inmates and staff, and to address persistent issues that have arisen at the MDC, including issues that the defendant himself complains of. Given that this major law enforcement operation was planned well in advance of the defendant's arrest, there could be no credible argument that the MDC sweep itself was meant to target the defendant. Indeed, no member of the case team conducted or was present during the search and only learned about the photographs once the search was complete. In sum, there is no evidence to support the defendant's weak suggestion that investigators one taken of the photographs of defendant's note was a targeted seizure. Nor is there anything improper about investigator one taking the photographs. Investigator one, who had reviewed the defendant's calls and emails in which the defendant overtly and persistently engaged in conduct that violated BOP rules and regulations, was entirely justified in inspecting the defendant's assigned bunk to recover additional evidence related to those violations and ensure the security of the BOP facility. Moreover, investigator one, who was not even bound by any privilege doctrine that may affect the case team, took steps to respect the potential privilege of the defendant's personal effects. Investigator one did not examine the manila folder labeled legal. He confined his review of materials to the notebook labeled redacted. Moreover, none of the steps taken by investigator one while he was searching the defendant's bunk were done at the case team's direction. Indeed, the case team was not aware at the time that investigator one was participating in the BOP sweep. Second, the government's use of a filter team to review the photographs in the first instance is entirely appropriate and adequately protected any potential privileged documents. As is consistent with the practice in the district, the filter team's review segregated potentially privileged materials as evidence in the redactions contained in photographs. Here, where the photographs related to the government's ongoing covert grand jury investigation, the government had no obligation to seek defense counsel's view of privilege determinations made by the filter team. Finally, the photographs and what is depicted in them are not privileged. The defendant does not argue, nor could he, that the notes in the photographs were prepared for the purpose of obtaining legal advice. Contrary to the defense counsel's mischaracterization, the photographs do not reflect notes to defendant lawyers concerning defense witnesses and defense strategies. Rather, the photographs depict the defendant's wide-ranging notes to himself, including notes related to the defendant's business interests, his release of music, family matters, among other things. Under the law, these sort of notes are not protected by the work product doctrine. Even if there was a disclosure of privileged material to the case team, that alone is not a basis for the relief that a defendant seeks. Indeed, in order to be entitled to a hearing to determine whether the prosecution was tainted by exposure by privileged information, defendants have the burden of showing a factual relationship between the privileged information and prosecution. The defendant has not done so here, particularly given the government's good faith use of the filter team. I'm just making sure I don't skip anything. Conclusion. For the foregoing reasons, the government respectfully submits that an evidentiary hearing is not required or appropriate under the law. Respectfully submitted, Damian Williams, the district attorney. So that was document number 72, filed on 8/11/18 as well. Hey, so there's that. Good to see you. Thanks for being here. We're just catching up on, Diddy documents that I haven't been able to get caught up on. Let's move on. So this is the third document filed on 11/18, and this is document 73. And this is from Lawyers Diddy. So let me pull it up. That was well written. I agree. Chicken nugget. Okay, let's move on. Dear Judge Submarinian, we write on behalf of our client, Mr. Sean Combs, to respectfully request that the court direct the United States Marshal Service to unshackle Mr. Combs prior to him in the court, bringing him to the courtroom for tomorrow's hearing and for all future court appearances. During the conference held on October 10th, 2024, Mr. Combs appeared in leg shackles throughout the entire proceeding without any justification. This was noticed by the press and the public. It is beyond dispute that a defendant may not be tried in shackles unless the trial judge finds on record that it is necessary to use such restraints as a last resort to satisfy a compelling interest such as preserving the safety of persons in the courtroom. While the Second Circuit declined to extend this rule to other pretrial proceedings, that decision was premised on the assumption that shackling during pretrial proceedings, unlike trial, would not impact the paramount concerns of juror basis. Given the press attention on the pretrial proceedings in this case, there is substantial risk that potential jurors will learn about the shackling through the media and develop such bias. In addition to the concern that shackles will prejudice the jury, the Supreme Court has identified 3 other fundamental legal principles that weigh against shackling. 1, the presumption of innocence and the fact that shackling undermines the presumption of innocence and the related fairness of the fact-finding process. 2, the Sixth Amendment right to counsel and participation in one's own defense and the fact that shackles interfere with the accused's ability to communicate with his lawyer. And 3, the dignity and decorum of judicial proceedings, including the respectful treatment of defendants. For these reasons, the Ninth Circuit has held that shackling during pretrial proceedings, absent a finding of necessity, is unconstitutional. Because there is absolutely no reason to shackle Mr. Combs during proceedings, because such shackling prejudices the potential jury pool, undermines his presumption of innocence, interferes with his ability to communicate with counsel, and offends the dignity and decorum of the proceedings, we respectfully request that the court direct the U.S. Marshal Service to remove his shackles before bringing him into the courtroom. And that was filed by 𝗟𝗏, Diddy's lawyer. So he don't want to be shackled during court. I don't have really anything nice to say about that, so I guess I just won't say it. Document 74. Also from Diddy's lawyer, and this was filed on 11/19. So the next day. Let me zoom in and share it on the screen for you guys. Hey, Scott, good to see you. Thanks for being here. Yeah, I believe Diddy is a flight risk. I don't think he should be let out on bail. I think he has too much money, too much power, and knows too many celebrities. Hey, Travelin, good to see you. Yeah, I agree. Mad Diddler, quicker they lock him up. I know. I'm really curious to see how this ends up. Sarah says, no, he needs to look how he should in shackles, what he did right. Right. He has no humility. I agree. He has no humility. Okay. Document 74, 1119. Dear Judge Submarinian, Subramanian, I think I'm saying that right. We write on behalf of our client, Sean Combs. Wait, I'm sorry. This is the response. Granted, the clerk of court is respectfully directed to terminate the motion at docket 73. Wow. So that was no response. That was the same document. So let me pull up the next one. Document 75, 1119. So this is right before the hearing that we just saw all over the internet yesterday. Okay, dear Judge Submarinian. The defense writes this letter in advance of today's hearing and in response to the government's letter of November 18, 2024. Document 72. The government's letter only reinforces the fact that the government has committed an egregious, willful, and harmful breach of attorney-client privilege and has become privy to defendants and defense counsel's trial strategy, including areas of expert testimony, witness strategy, and other confidential matters. 1. The materials provided to defense counsel. Defense counsel has been provided with 19 pages of materials seized from Mr. Combs' locker at the MDC. According to the government, these 19 pages were given to and are in the possession of the trial team, which has already started using these privileged materials to its advantage, including its opposition to bail. Based on the materials provided at Exhibit A, it appears a government investigator, Investigator 1, took photographs of several different items. This included intact pages from 2 different legal pads, pages of an address book, a ripped out, folded over page of a 3rd legal pad, ripped out page of another legal pad, and a ripped out page of yet a different legal pad, as will be described below. The first page is a page from the folded over intact legal pad. The second page is a copy of the first page, but it is partially enlarged. Pages 3 through 11 are pages of an address book. The 12th page appears to be the first page of a second legal pad. The 13th page is a second photograph of the same page. Pages 14, 15, and 16 appear to be folded over pages of the same intact legal pad. Page 17 is a single folded piece of paper removed from yet another legal pad. Page 18 is a single sheet of paper ripped out of a legal pad. Page 19 appears to be a ripped out single sheet of paper from a 4th legal pad. This legal pad has no vertical line on the left side. Also, this legal pad has 21 lines, whereas the first 2 legal pads have 35 lines. Based only on the materials provided, it appears that the investigator took photos of more than only the notebooks and the address book, as represented in the government's November 18, 2024 letter. Rather, he appears to have taken photographs of these pages of several legal pads, both pages that were intact in the legal pad as well as the loose pages. It bears reminding that these clear written statements of the defendant were not provided to the defense as part of the government's discovery or Brady obligations. If it were not for the fact that the government used portions of these privileged materials in an effort to hold Mr. Combs in jail, we would still never have them or even know about them. And Brady comes into play in the Alec Baldwin case. If you didn't follow that, that's basically what got him off. Yeah. Hey, Carrie. Good to see you. Happy weekend. Happy Saturday to all of you. Thanks for being here. We're just reviewing the documents from Diddy that I've missed. Let's continue. 2, the notes are obviously privileged. Of the 19 pages provided to counsel, 11 pages are Mr. Combs' notes to and with his lawyers. These notes reflect actual conversations with his attorneys concerning aspects of his trial preparation and his efforts to be released on bail. These notes refer to defense counsel by name, which include discussion of defense experts and witnesses, discuss cross-examination and credibility of witnesses, and the overall defense strategy. Mr. Combs' handwritten notes covering legal strategy are now in the hands of the trial prosecutor, who hope to take advantage of the breach they committed to better prepare for the May 2025 trial, bring new charges, and argue for Mr. Combs' detention. Mr. Combs keeps his legal materials in his locker. His notes are in the form of number legal pads, several of which the government has photographed, as well as loose pieces of paper which he makes notes. On top of his legal pads and notes, he has a folder marked legal. This is to put anyone on notice that everything along with the folder marked legal is exactly what it says: legal attorney-client materials that he brings to his meetings with his lawyer to prepare his investigative and his trial strategy. When he finishes meeting with his lawyers, he brings his legal materials back to his locker where they are kept with clear warning written on the folder that these are his legal materials. So when investigator 1, who we will get to in a minute, saw a manila folder marked quote unquote legal, this was his cue that all the legal pads and loose pages of legal pads that accompanied it were Mr. Combs' legal materials. Mr. Combs counsel previously attempted to provide him with red will folders to assist him in organizing his legal papers, but those materials were rejected by the MDC. If the warning legal wasn't enough, the notes are obviously legal materials that he discusses with his lawyer. They repeatedly refer to his lawyer by name. On the 14th page, he writes, redacted. He wrote that redacted. It is hard to imagine more self-evidently privileged conversation than a trial lawyer telling a defendant about a redacted, and the defendant writing it down in his legal materials because it is so important. On that same page, Mr. Combs wrote about redacted. This is heartland trial strategy being expressed in detail in notes of conversations between Combs and his lawyers. The fact that a government investigator, government taint team, and the entire prosecution team viewed this and still believed they could keep the notes and use them against Mr. Combs is unfathomable. Worse still, that the government took notes directed to his lawyer to redacted in preparation for trial and then used those notes as a basis for claiming that he was attempting to tamper with witnesses is astonishing. As discussed above, the notes are replete with discussions of legal strategy between Mr. Combs and his lawyer, all of which should have been obvious to everyone who looked at these notes: Investigator 1, the taint team, and the trial team. Is there proof that they read his legal documents? I mean, probably. I don't think they would be filing all these documents if they didn't have proof or some kind of reasoning, right, that would help them. No Diddy, huh? I know. Carrie says, maybe they make a duplicate copy for him to bring to the room, aka cell, right? His bedroom. That's funny. Carrie also says, you would think he'd want to look over things and make notes while he does nothing at all in his day room. Yeah, I don't get it. Stell says, cha-ching, that is what I hear when you read his lawyers. I know. Let's move on. 𝗟𝗏𝗄 must be getting paid the big bucks. Number 3, and if you guys don't know who 𝗟𝗏𝗄 is, he actually prosecuted the guy in the cult from, oh my gosh, I know I covered it on my previous lives, but he was in his case, his lawyer as well. Oh my gosh, I'm blanking on his name. You guys know who I'm talking about. Keith Raniere. There we go. I'm sorry. And that was like the sex cult leader. Yeah. And he also represented some Russian banks, a Turkish Iran gold trader, a Syrian Lebanese GUN runner, and a couple other people. So he's been involved in pretty controversial cases. Let's move on. Number 3, the government did not inform defense counsel that it had Mr. Combs' notes as evidence that the government is acting willfully. As noted, the government did not produce these notes of defendant's own statements to the defense as part of its discovery obligation. The opening paragraphs of federal R crime required the government to disclose defendant's written or recorded statement to the defense. One would think this would be especially urgent when the written statements at issue are in the form of the defendant's own handwritten notes that were taken from his cell and which reflect specific conversations with counsel. But the government did not produce these in discovery, nor did the government's team establish for precisely this type of situation. Contact counsel and advise counsel that it was in possession of the defendant's handwritten notes. As part of the hearing and to determine what sanction is appropriate for this egregious self-evident privilege breach, defense counsel wants to know exactly how the decision was made and by who to not contact defense counsel when the United States attorney came into the possession of these notes. 4. The government's explanation of how it took these notes is riddled with self-contradiction and lacks common sense. The government referred to Investigator 1, whose role in these events is as mysterious as it is contradictory. The government states that Investigator 1 was assigned by the BOP to participate in the sweep and that he is not part of the government's investigation of the defendant. Yet the government also states that Investigator 1 has consistently monitored the defendant's communications. The government also states that it sent grand jury subpoenas and document requests to the BOP for the defendant's monitored communications. The letter is silent as to which BOP officials the prosecutors work with in communication with its efforts to secure defendants' monitored communications, but it would appear that the prosecutors work with, among others, Investigator 1. Under the circumstances, the hearing should encompass what connection exists between the prosecution team and Investigator 1. Second, the government writes that the BOP sweep was pre-planned, not in response to any particular threat or intelligence, and did not target 𝐂𝐚𝐬𝐡𝐀𝐩. However, the government also writes that there was nothing improper about Investigator 1 taking the photographs because Investigator 1, who had reviewed the defendant's calls and emails, was entirely justified in inspecting the defendant's assigned bunk to recover additional evidence. The government's position is immediately self-contradictory because of the review of the particular inmate's calls and emails is intelligence, and because acting on that intelligence in order to conduct a particular search is targeting 𝐂𝐚𝐬𝐡𝐀𝐩. The government's own letter shows that 𝐂𝐚𝐬𝐡𝐀𝐩 was treated differently from other inmates and that the search of his locker and the removal of his notes was based specifically on the intelligence that Investigator 1 developed from listening to his calls and reading his emails. Third, the BOP sweep was purportedly related to removing contraband at the facility. The release goes on to state, the combined operation identified and confiscated a number of electronic devices, rugs, and associated paraphernalia and homemade weapons. Yet, Investigator 1 apparently used the sweep as a pretext to conduct a targeted seizure of Mr. 𝐂𝐚𝐬𝐡's handwritten notes about conversations with his lawyers. Telling Investigator 1 did not report that he had, quote unquote, identified and confiscated Sean 𝐂𝐚𝐬𝐡's notes of conversations with his lawyers to his supervisors of the multi-agency law enforcement operation. He went straight to the prosecution team. The prosecutors have taken the position that the identification and photographing of Sean 𝐂𝐚𝐬𝐡's handwritten notes were merely part of the multi-agency sweep to rid the MDC of substances, electronics, and homemade weapons. There are ways of proving such a contention. We can call Investigator 1 to the stand at a factual hearing. A hearing should encompass what Investigator 1 told the prosecution team about the legal materials he rifled through. At a hearing, we could ask Investigator 1 why he called the trial prosecutors. What contact had they had beforehand? How did Investigator 1 know which notes to photograph? Did Investigator 1 photograph any notes aside from 19 pages defense counsel was provided yesterday? What, if any, direction did Investigator 1 have from the agents conducting the pre-planned law enforcement initiative, or was he taking directions from someplace else? The bottom line is that no multi-agency law enforcement initiative justified rifling through Mr. 𝐂𝐚𝐬𝐡's personal handwritten notes of conversations with his lawyers, and the prosecutor's arguments to the contrary lack all credibility. I mean, I'll give it to him. He's a good lawyer. He keeps trying and trying and trying. I agree, 𝗪𝐵. It's a very controversial channel. There's long time coming people trying for years to expose him, and no one believed them. Exactly. I agree, 𝗪𝐵. Yeah, I'm I'm not a big fan of Diddy. The evidence shows there was a law enforcement plot to photograph Mr. Combs' note, have the taint team not advise counsel, and use these plain privilege materials to keep Mr. Combs in jail and to gain an unfair trial advantage. Before Friday evening at 11:30 p.m., defense counsel knew none of this. It was not until the government attached 2 pages of defendant's handwritten notes to a letter to keep him in prison, and the defense counsel learned for the first time that over 2 weeks earlier, Mr. Combs' notes were photographed and provided to the U.S. attorney. In the last 4 days, several things have become clear. First, Investigator 1, who had been monitoring Mr. Combs' calls and emails, was absolutely targeting him, seized upon an opportunity to search his cell. He knew that there was a completely unregulated multi-agency law enforcement measure planned for October 28, 2024, one related to ridding the MDC of weapons, substances, and cell phones, and having nothing to do with the inmates' notes of conversations with his lawyers. Because he had been monitoring Combs' conversations, he conducted a warrantless search of Mr. Combs' papers, not looking for weapons, substances, or cell phones, but for what Mr. Combs and his lawyers were discussing and what Combs' trial strategy would be. In a high-profile case such as this, where the defense has been usually outspoken about the lack of meaningful inculpatory evidence, what could be more valuable than photographing defendant's trial strategy with his lawyers? So he photographed pages where the defendant discussed what types of expert witnesses to call, where he identified witnesses, where he discussed his thoughts about the credibility of the most important witness in the case, and other things revealing the defense trial strategy. Once he photographed these pages, he returned the legal pads and other documents to their original location so the defendant would have no idea his handwritten notes had been taken in this manner. One of the most important witnesses in the case. Who's that? Who do you guys think? Let's continue. Then he called his trial prosecutors in this case to aid in their investigation, and because he knew he had information that would help him, defendant's trial strategy laid out in his own handwritten notes. Whether he revealed them to the prosecution team even more privileged information than what is contained in the notes remains to be seen. Next, at the prosecution's team's direction, he sent the note to the U.S. Attorney's Office to the taint team, whose sole purpose is to ensure that attorney-client privilege material is not given to the prosecution team. At no point does a taint team contact defense counsel. At no point does a taint team state that it is in possession of Sean Combs' handwritten notes. At no point does a taint team ask defense counsel if anything in these handwritten notes is potentially privileged. Given that there was an established protocol in place, it is inconceivable that there is mere oversight. Similarly inconceivable is how the taint team, intensively trained to review for privileged material and provided with the names of all defense counsel, somehow did not see the obvious privileged nature of the notes. The notes referred to defense counsel by name, included discussion of defendant's experts and witnesses, discussed cross-examination and credibility of witnesses, and overall defense strategy. The taint team even recognized that the portion of the notes written on the very same page contained privileged information, yet failed to realize the privileged nature of the rest of the page. The fact that the prosecution team had then received these notes from the taint team and likewise failed to understand what had come into their possession is just as egregious. At some point, the trial team comes into possession of the 19 pages of materials. At no point does the trial team contact defense counsel to state that there are references to particular potential witnesses or to possible areas of expert testimony, or even to the fact that Combs specifically writes that blank, which is redacted. The trial team didn't tell defense counsel of any of this for the same reason the taint team didn't tell defense counsel, and for the same reason that Investigator 1 targeted Combs and photographed these notes in the first place, because there was a plot to get these attorney-client materials. And once they got them, the first thing they did was use them specifically by putting them in a bail letter to keep Combs in jail. Number 6, a fulsome hearing is required. The government's proffered explanation for how it got this information is internally inconsistent and not credible. As a result, a hearing is required. Respectfully, 𝗪. All right, what do you guys think? This is wild. Yes, please hit that like button. Help your girl out. We're almost to 1K subs. Hell yeah. That's awesome. I appreciate all the support. The next document is just one page. Thank you. So there's that. I appreciate you being here. Just a matter of time before you get caught. Yeah. Too bad this started in like the 90s. The government doesn't need his docs. There's so many victims and tons of proof. Yeah, I mean, he's locked up, so I don't know how much privacy he expects, but nonetheless, let me pull up the next document. This is document 76, and it is 1 page. For the reasons stated at the hearing held on November 19th, the government must immediately delete the photograph notes at issue pending the court's ruling on whether they are covered by attorney-client privilege. The government should confirm on or before November 21st that the notes have been deleted. Based on the government's representation that the filter team has no involvement in either the grand jury investigation or this litigation, or the filter team may retain copies of the photograph notes but may not provide them to anyone else. Briefing on defendant's application relating to the notes will follow this schedule. Defendant's brief to be filed December 4th, the government's response by December 9th, and defendant's reply by December 11th. The briefs should include citations to the best cases supporting or refuting the requested relief. Finally, the defendant's reply brief on his renewed motion for bail at docket 60 is now due on Thursday, November 21st. So ordered, the judge. So December 4th, December 9th, and December 11th, we'll probably be reviewing some more documents. All right, that was document 76, and that was filed on 11/20. Thank you, Stella. I appreciate you. Thank you for being here. All right, so let me pull up document 77. This is also 1 page. And this is from the judge as well. So let me pull it up. 77. I need to keep track because I'm like all these Diddy files. In his November 19th letter to the court, defendant stated that a government investigator took photographs of several items, including intact pages from 2 different legal pads and ripped out pages of other legal pads. The letter also described the legal pads in detail and argued that they were privileged in part because on top of his legal pads and notes had a folder marked legal, which put anyone on notice that everything with the folder marked legal is attorney-client material. At the November 19, 2024 hearing, defense counsel presented the court with an intact legal pad with legal written on the binding, stating that the legal label on this and other labels showed that they were clearly protected by attorney-client privilege and should not be in the government's possession. The court notes that the sealed exhibit to government's brief 72, which we just read, includes photographs of 2 intact legal pads taken at the time of the BOP sweep. There's no handwriting on the binding of either pad. At the scheduled hearing on Friday, November 22nd, defense counsel should be prepared to give the court further context on the legal label that the court was presented on November 19th hearing and to address why this label doesn't appear on the photographs in the court's possession and why it wasn't addressed in the defendant's submission to the court made a few hours before the November 19, 2024 hearing. So the judge is saying that at the time of the photographs, it didn't say legal. I know he did that. He think he wouldn't get caught. His time ran out. Too bad people had to suffer because of what he did. I'd like to know what his family really thinks of it all. Will they stand behind them? Are they shocked? Did they put him through similar things? Yeah, I think his family members are probably victims too, in my opinion. But all of the above, I agree with you, Augie. Okay, so that was document 77, and that was filed on 11/20. And so now we have document 78. And this is from I'm not sure. We're going to read it. It's just 1 page. From Shapiro, LLP. Dear Judge Submarinian, On behalf of the defendant, 𝐁𝐿𝐴𝐻, we respectfully request permission to file a reply memorandum of up to 16 pages in support of Mr. 𝐁𝐿𝐴𝐻's renewed bail motion to ensure that we have sufficient space to respond to the new material in the government's opposition. The government has advised us that they consent to the proposed relief. We thank the court for its consideration of this request. So they're just being professional there. Let's move on to document 79. Let me pull it up. I appreciate you guys for being here. So document 79 is just their response from the judge. I'll read it. It's just a sentence. Granted. However, the parties should make every effort in the future to ask for relief of this kind in a timely fashion. The clerk of court is respectfully to terminate the motion at number 78. So it was granted. Let's move on. Document 80. Reply memorandum in further support of 𝐁𝐿𝐴𝐻's renewed motion for bail. Here we go. Filed 11/21. And this one is pretty long, so I'm just going to read the intro and then we'll get to the good part of it since we've already heard a lot of it. The government persuaded Judge Carter to detain Mr. 𝐁𝐿𝐴𝐻 by claiming its video of an 8-year-old incident was evidence of sex trafficking and by making unsubstantiated claims of witness tampering. The defense rebutted those arguments through its own proffer, but lacked access to key evidence that could not corroborate its rebuttal. Nearly 2 months later, much has changed. Most importantly, discovery produced after the initial bail hearing, some of it after the motion was filed, shows the narrative the government presented was fictional. For instance, we know that even before it's arrested Mr. 𝐁𝐿𝐴𝐻, the government possessed, redacted, confirming his account of the March 5th, 2016 incident at the Intercontinental Hotel. But instead of presenting that video to the court, the government submitted an altered video that omitted key scenes and presented events materially out of order. The prosecutors also claimed there was a second victim, but they never have interviewed her, and messages produced in discovery confirmed she was not a victim. Likewise, communication produced in discovery show Mr. 𝐁𝐿𝐴𝐻's contact with witnesses were innocuous and consistent with his right to participate in his defense by developing potential defense witnesses. Karma is very real. I've learned people cannot get away with things forever. If you continue to do dark things, it will be brought to light. I agree. I agree, Carrie. I think he's really going to get most of everything the prosecution asked for. Yep, I agree, Sarah. Okay, let's move on. The government's opposition brief confirms that bail should be granted. It spills much ink insisting that the court lacks authority to reopen the bail proceedings, even though the controlling authority establishes the court's ample discretion to do so. The government also offers no response to many of the cases cited in Mr. 𝐁𝐿𝐴𝐻's motion, including 2 other sex trafficking cases in which bail was granted. So this is where Diddy's lawyers are referring to the Abercrombie CEO and the lawsuit that he just recently got slapped with for sex trafficking and how he was let out on bail. So I will be reading that here, that document as well. I'm interested. Let's move on. Instead, the government reprises the same disingenuous tactics it used in the prior proceedings. It took full advantage of detention order, scouring Mr. 𝐁𝐿𝐴𝐻's communications to try to find some actual evidence to substantiate its obstruction allegations. But once again, the government's theatric spin on the evidence omits key context and creates a misleading picture. For instance, it makes much of Mr. 𝐁𝐿𝐴𝐻's contacts with others, but it is unable to point to any communications involving actual tampering efforts. And it omits key parts of conversations which show that Mr. 𝐁𝐿𝐴𝐻 was not pressuring anyone or telling anyone what to say about anything. Likewise, its allegations about MDC rule violations are false or overblown. There is no legitimate legal basis for continuing to force Mr. 𝐁𝐿𝐴𝐻 to prepare for trial from jail. The government is unable to show that the extremely restrictive proposed conditions are insufficient to prevent any possible danger or obstruction. The revelations about the recent MDC raid only confirm that it is impossible for Mr. Combs to work with his counsel on a confidential basis to develop his trial strategy from the jail. He is entitled to a pretrial release under the Bail Reform Act and Constitution. The argument. The court should exercise its ample discretion to reopen the bail hearing. Mr. Combs presents new material information. The government's effort to disparage the significance of new evidence supporting Mr. Combs' motion are nothing more than empty rhetoric. The evidence cited in Mr. Combs' motion fundamentally undermines the government's prior representations as to the weight of evidence and the nature and seriousness of the purported danger he presents. That is more than sufficient to demonstrate changed circumstances, which is satisfied by showing the strength of the primary evidence relied upon by the government to demonstrate danger has been undermined by new information. The specific evidence outlined in Mr. Combs' motion was not available at the time of the initial hearings. Although the defense had a general understanding of Mr. Combs' past interactions with individuals like victim one, we did not have access to the specific contents of the relevant correspondence because it was contained on devices that were seized from Mr. Combs but had not yet been produced to him. Thus, the government's claim that nothing about the context of the text messages between the defendant and the victim one were unknown to him at the time of the initial hearing is false. The government does not dispute that other evidence, such as redacted, could not have been known to Mr. Combs during initial hearings. As just one example, Mr. Combs did not know that redacted directly contradicted the government's claim at detention hearings, nor did Mr. Combs know that the government was portraying a second woman as a purported victim, even though it had never spoken to her. This is sufficient new information to reopen the hearing. The government's separate argument that the court has no inherent authority to reopen the hearing because this case has been reassigned is baseless. The court is entitled to consider the basis for the detention order in deciding whether to reopen. We are not asking the court to rule that Judge Carter erred, which is that United States adjust when it observed that a second district court judge is not authorized to review the decisions of a previous district court judge. We are simply offering new evidence and additional conditions in response to the reasons Judge Carter gave for detaining Mr. Combs. As the Second Circuit has clearly instructed, the act leaves the decision to reopen a hearing to the second discretion of the district court. And a prior detention determination is a natural reference point against which to measure the materiality of new information for the purpose of reopening the hearing. On November 13, 2024, the government produced even more material new evidence, including more redacted, of the March 15, 2016 Intercontinental Hotel incident. The government had this redacted as early as August 7, 2024, yet not only produced it to the defense after Mr. Combs filed his renewed motion for bail. The redacted consists of redacted. Redacted used to create the government's principal piece of evidence at the earlier bail hearings, an edited, manipulated version of the video published by CNN. The new video supports the defense argument at the early bail hearing and shows the government's knowingly mischaracterized and concealed critical facts during these hearings. As an analysis prepared by the forensic video analysis, 𝐿 explains the video the government submitted to the court omits footage corroborating the defense account, changes the sequence of events in material respects, and does not accurately depict the events. So they're basically saying that the video was altered, the 𝗏𝐶 video that we all saw. Which, I don't know. Do you guys believe that? Do you buy it? Let's move on. The government had more complete redacted during the initial videos, but chose not to share it with the court. Instead, it offered its edited version of the CNN video as its most powerful evidence of danger and obstruction. Mr. Combs argued Exhibit A1 was not an evidence of a freak-off, but depicted a domestic dispute in which he ran down the hall of a hotel to recover his clothes and cell phone. The government invented a different narrative. It argued Our evidence will show that's just not what happened, because if it's about the clothes and wanting to get the clothes back, which again, it's not, why drag the victim back down the hall to the room? And you can see that on the tape. That's what he does. The government further argued Mr. Combs throws a vase at her, which the district court cited in detaining Mr. Combs. The government apparently stands by those arguments again here, but they are false and the government knows it. The more complete footage of the incident, in contrast to the government's sensationalized CNN cut, contradicts the government's representation. The video demonstrates that Mr. Combs, in fact, ran down the hall to retrieve a bag of clothes and a cell phone. He did not drag victim back down the hall to the room, as the government and its resequenced exhibit falsely suggest. He did not throw a vase at victim one, but only its contents. And she was not only able to leave once security staff intervened. In other words, it is the government whose explanation is just another cover-up, just more lies. The true facts corroborate what Mr. Combs has stated all along. The video is not evidence of a coerced freak-off and sex trafficking, but rather a sad glimpse into a decade-long consensual relationship between Combs and victim one. The new evidence undermines the government's initial proffer. I disagree with that. We saw the video. Why was Cassie going to try to take, or victim one going to try to take his clothes? And that's the reason why he dragged her back in there and ran out half naked. Like, I don't know. That doesn't make sense to me. Yeah, he sure did apologize when he was like, oh, I got the help I needed. He said he was sorry about what he did, and then things got worse. I know. Anyways, let's move on. Mr. Combs' new evidence undermines the basis for the initial detention decision, and none of the government's more specific arguments demonstrates otherwise. Communications with victim one do not evidence sex trafficking. Not one piece of correspondence that we have reviewed between Mr. Combs and victim one, the sole victim in the indictment, corroborates the prosecution's trafficking theory or its representation as at the previous bail hearings. And the government still does not offer a single piece of actual evidence supporting the allegation. Instead, it reiterates its proffer of cherry-picked citations to purported messages. If the messages in context actually support the government's argument, why hasn't it produced them to the defense or provided them to the court? The government brushes off victims one motives for accusing Mr. Combs as having no bearing on the question of bail. But victim one is the only victim identified in the indictment, and her credibility will be if not the key issue at trial. If the jury does not credit her testimony, it will have to acquit him of the trafficking count. Her motives thus directly relate to and diminish the weight of the evidence against Mr. Combs, as well as the nature and seriousness of the perpetrated danger he presents. The government does not even dispute that despite labeling a second person as a victim of trafficking, it has never even spoke to her. Presumably for this reason, the government also fails to dispute the fact that this individual was voluntarily intimate with Mr. Combs for years. So there's a second victim who was hooking up with Combs that we don't know about. So then there's two whole sentences that are redacted. The government now falsely portrays as sex trafficking. The government simply has no response to these facts. Instead, it doubles down on more misleading representations to the court. It suggests Mr. Combs is tampering with this individual through financial coercion, including as recently as mid-September 2024. Yet the government knows, but again, withholds from the court that redacted. You see all the redactions. There is simply no financial coercion at all. The government's discussion of Mr. Combs' contacts with witness one contains no facts suggesting any tampering. The government does not and cannot dispute that Mr. Combs did not try to influence the individual's grand jury testimony. To the contrary, he confirmed the witnesses should redacted. Indeed, his contacts with the witness were in coordination with counsel and in connection with the defense investigation. The government cites 128 phone contacts in total with witness 2, but ignores that the content of the correspondence evinces no obstruction. The most the government can offer is that redacted. There's like 2 more sentences redacted. That is all and is not evidence of obstruction. The government concedes that in considering whether release is necessary for preparation of the person's defense, the Bail Reform Act requires that a defendant in custody be afforded reasonable opportunity for private consultation with counsel. The government's breezy assurance that the MDC's procedures do not infringe on the defendant's constitutional right to effective counsel or to participate in his defense is cold comfort, particularly given what the opposition revealed about how the government has taken advantage of the detention order to violate Mr. 𝐶𝐬's privacy and pierce his privileged communications with his attorneys. The government has listened to his calls, including with family members and attorneys, and reviewed his messages, including with dozens of individuals, including our attorneys. The BOP sweep and prosecutors' conduct here will unquestionably have a chilling effect on Mr. 𝐶𝐬's preparation if his detention continues. The government's response, that is, that its actions need only be reasonable, not perfect, provides little comfort. Defense counsel has repeatedly tried to come to an agreement with the government on various issues, including the sharing of discovery with Mr. 𝐶𝐬's and clarifying the filter team's protocol. These issues remain unsolved. The government says it will provide a laptop in short order, but it has been saying that all along, and while it has made a laptop for counsel to bring into the MDC available for this week, it still has not provided a laptop for Mr. 𝐶𝐬's to have in the facility. The government has done nothing to remedy the issue raised by motion. To the contrary, it hid from the defense that Mr. 𝐶𝐬's privileged materials and work product were search and seize. The comment that it stands ready to engage with defense counsel on these issues if needed is hard to take seriously given the history here. Nor is the suggestion that Mr. 𝐶𝐬 should consent to further delaying the trial if detention makes preparation impracticable. He has constitutional and statutory rights to a speedy trial. I'm going to touch base with you guys. They will never give him bail. I don't know. You guys don't think he'll get bail? I'm nervous about it too, Tipsy. I feel like he might get it. If they're thinking about it and waiting for the weekend, I don't know. I feel like he might get it. Laptop, he needs to go to the kiosk. I agree, Chicken Nugget. Top Cat says, I don't think they will let him out. What did Scott say? He is involved in way more. I agree, Stella. I cannot stand the other. Oh, yeah, you're fine. Okay, let's continue. Mr. 𝐶𝐬's use of methods of communication that the government claims violate BOP policy does not evidence obstruction and does not justify detention. It is simply not true that the communications are designed to evade BOP and law enforcement monitoring. ContactMeASAP.com is a service that the defense counsel did not believe was unauthorized by BOP as it is widely used in prisons. Defense counsel has spoken multiple times with the administrator of the website to confirm that this method of communication utilizes the BOP's trunk link system, which it does, and is monitored by BOP officials, which it is. The government therefore can read and even block every single message Mr. 𝐶𝐬 sends and receives through his service, as with Mr. 𝐶𝐬's understanding. Indeed, the government has never once instructed defense counsel to have Mr. 𝐶𝐬's refrain from using the service, nor has the BOP. Mr. 𝐶𝐬's is no longer using ContactMeASAP.com as of November 16, 2024. The use of other inmates' PAC number is also a widespread practice at the MDC and not obstruction. Inmates routinely share their calling minutes with other inmates, and they're limited to 15 minutes per call and 1 call per hour. The government has presented no evidence suggesting anything Mr. 𝐶𝐬 says using other numbers is any different from what he says while using his individual PAC number. If anything, that Mr. 𝐶𝐬's needs to resort to sharing minutes demonstrates that the conditions at MDC do not permit an adequate defense preparation. Although this is technically not permitted by BOP policy, the BOP effectively sanctions the practice and all calls are monitored. The government claims to have reviewed multiple calls in which Mr. 𝐶𝐬's has attempted to dial in third parties, but it does not describe how any of these calls could be attempts at obstruction. While it states that the potential contacts in these calls include members and associates of the enterprise, because the government will not identify these individuals, the defense has no way of testing the government's claim. Indeed, redacted. The communications do not evidence obstruction. The messages cited by the government reflect Mr. Combs' efforts to investigate and prepare his defense, including with counsel's participation, nothing more. And then there's 3 sentences that are redacted. At the time, the defense team did not even know that this individual was a purported victim. Interesting. Redacted again. Of course, the government continues to portray the individual in question as a victim who could provide powerful testimony against Mr. Combs. Mr. Combs' Sixth Amendment rights would be violated if counsel did not adequately conduct a thorough investigation into the individual, and any such investigation must be based quite properly on informed strategic choices made by the defendant and on information supplied by him. Indeed, what investigation decisions are reasonable depends critically on such information. Accordingly, courts are mindful of pretrial detainees need to make phone calls to potential witnesses and other individuals who might be useful to the defense. Mr. Combs' comments to that effect do not evidence obstruction. The government completely mischaracterizes the content of blank on Exhibit L. And then there's a whole 4 sentences redacted. And by the way, these exhibits they mention, they are sealed as of right now. So I couldn't show you guys because they're sealed. Let's see. The music video for which was never released. Oh. The government mischaracterized the content of blank on Exhibit L, and then it's redacted, and then it says the music video for which was never released. The quotes cited by the government tellingly include no reference to victim 1 because they aren't references to any videos or public relations strategy to discredit her. The government also cites comments reflecting classic protected speech. The government claims using public statements to alter public perception and redacted is obstructive. It argues the same regarding establishing a narrative about redacted. Mr. Combs' belief that this is redacted and his persona as a redacted. Without question, a pretrial detainee does not necessarily forfeit his or her First Amendment rights. Indeed, as the Supreme Court has held, in some circumstances, press comment is necessary to protect the rights of the accused because the defense does not begin inside the courtroom door, and one cannot argue the practical implications of a legal proceeding for the accused. The cited conduct does not demonstrate any real or specific threat to the legal process, and Mr. Combs' statements have the full protection of the First Amendment. Gentile consideration to the appropriate standard for speech restrictions on a lawyer, but Mr. Combs, who is a criminal defendant and is presumed to be innocent, has a greater constitutional claim than other trial participants to criticize and speak out against the prosecution in the criminal trial process that seek to take away his liberty. His comments, which were not even made but merely anticipated, involve thoughts that this prosecution is politically motivated or that he is innocent of the charges against him, which would constitute protected speech. To the extent the court remains concerned that such statements might interfere with a fair trial, the remedy is not to detain the defendant, which would chill free speech. Instead, it is to screen potential jurors through the voir dire. Moreover, the Bail Reform Act authorizes courts to release pretrial detainees on condition that they avoid all contact with an alleged victim and with a potential witness. UC 18, which mitigates the specific obstruction concerns raised by the government. The government claims its detention request is supported by witness testimony, communications, photos, and videos, police reports, and other materials, but it has produced no such evidence. The only testimony in the bail record confirms that redacted. The communication it continues to rely on include innocuous messages sent by purported victim 2, an individual that the government has never spoke to, and one it knows isn't a victim. And its piece de resistance, the video involving the only specific victim mentioned in the indictment, is not evidence of trafficking as explained. The government again reiterates the indictment's allegations, but offers no response to the case law, illustrating why those allegations are insufficient to meet its burden. B, there's no risk of flight. Mr. Combs fully intends to face these charges. This prospect of a conviction does not materially change his incentives here, where his reputation has already been destroyed by the government's allegations and aggressive and depictive media tactics, and can only only be rebuilt by winning at trial. As the government concedes, Mr. Combs took steps to mitigate the risk of flight before the indictment, and there's no credible risk that he will attempt to flee if committed to the 24/7 custody of qualified security personnel. That sounds like entitlement. Yes. Hi, Dragonfly. Good to see you. I'm glad you made it. And I saw Life Artist. Hi, love. I'm glad you made it. Thanks for being here. Make sure you guys hit that like button. Whoa, we have a double header. You know it, Dragonfly. It's good to have you here. Let's move on. We're almost done with this document. C, the proposed updated bail conditions are sufficient. The proposed conditions specifically mitigate any possible concerns. The government cites perpetrated obstruction carried out through phone and email, but under the proposed conditions, Mr. Combs will have less access, in fact, no access to such means of communications other than communicate with counsel. Moreover, family visits will require prior approval, and Mr. Combs would consent to security personnel monitoring the visits and video monitoring if necessary. Tellingly, the government does not even attempt to distinguish the precedent supporting release on comparable conditions in similar cases. Indeed, the government consented to release on conditions of 2 defendants in the Jeffries case since the initial bail hearings here. Again, they're referring to the lawsuit filed against the Abercrombie CEO. Appreciate you, Dragonfly. The government is also wrong that United States versus Bustani favors detention, as explained in Mr. Combs' reply on appeal, which he incorporates here. Bustani stated a private security arrangement may be appropriate where the defendant is deemed to be a flight risk or danger primarily because of his wealth. That is exactly what the government has argued and alleged in this case, claiming that Mr. Combs has nearly limitless resources to facilitate his flight. Indictment alleging racketeering activity fueled by employees, resources, and influence of Mr. Combs' business empire. Bustani cannot foreclose to release where the government repeatedly emphasized the defendant's wealth and explaining the risk of flight. Throughout these proceedings, the government has sought detention without actual proof, only to later produce evidence revealing the true, materially different facts. Because the accuracy of its proffers are in question, they should be disregarded, and the court should only rely on the underlying evidence or evidentiary sources. Conclusion. For the foregoing reasons, the court should reopen the hearing and grant bail on the proposed conditions or any other conditions the court deems appropriate. And that was dated November 21st. What do you guys think? Is he a flight risk? Should he get bail? What is it? What's the Diddy vibe? That was document 80. So we have 2 more to go. Let me get them pulled up. Oh, okay. There's attachments, but like I said, they're under seal. So we clearly cannot see those. So document 81. Again, he wants home confinement in Miami. I don't think he should be let out. So this other document was filed on 11/21. No bail repeatedly. I know, I agree. All that money, he can fly anywhere he wants and he won't flee. Yeah, okay. Or pay people off. And he's like, I won't talk to anyone or use the internet. And it's like, really? In your mansion with all the people you have, you're not going to do any of that? I don't buy it. Sorry, I was drinking some water. Okay. Filed 11/21, document 81. Terry Rose Garagos, I am a partner at 𝐻𝐿. I am licensed in good standing. This declaration is based on my personal knowledge of the facts stated herein. The defendant and defendant's counsel efforts to interview witnesses. Mr. 𝐻𝐿 and I began interviewing witnesses for this matter on April 2024 after the Department of Homeland Security raids at 2 of Mr. Combs' residences on his person. Mr. 𝐻𝐿 stated examples of the interviews at the bail hearing on September 17, 2024. And then there's bullet points. The first bullet. So Ms. 𝐿 and I have interviewed a half dozen of these males. We have been as busy as the government has over the last 6 months. Bullet point 2. They talk about other violence in their bail letter, and they are talking about kidnapping from 2011, and I know exactly what they are talking about because we interviewed, I know who the person who was alleged kidnapped. Ms. 𝐿 and I interviewed her in Los Angeles. We took a statement from her. She certainly didn't use the word kidnapping with us. I won't get into what she did say, but let's suffice it to say there's another side to that story, and one day that other side might be told. Next bullet point. Are we going to continue interview witnesses? Of course we are. We take pains to stay out of the government's way. We don't know who the grand jury witnesses are, you know. And honestly, I won't get into the details. If I think they are talking to someone, I will pull up short. I don't want any problems. You know, do I want to speak? We both know pretty much everything, you know. Number 5. After Mr. Combs' indictment on this matter, the government and I began negotiations over the protective order. Because we had protracted discussions, we did not come to the agreement on terms until October 4th, 2024. The court has entered the agreed upon protective order on or about October 7th, 2024. That evening, the government produced their first production of discovery material to the defense. This production included the government's search warrants and their supporting affidavits. Even without the benefits of the government's discovery, Mr. 𝐷𝐼ITG and my investigation continued. In the beginning of October, our investigator traveled to the redacted to interview multiple witnesses. He had planned to interview people in redacted. On October 2nd, 2024, our investigator was in redacted interviewing a witness. He then traveled to redacted to interview redacted we believed may have important information related to the investigation. On October 3rd, 2024, I met with my client at MDC and discussed redacted with him. We discussed redacted. This individual who as the government states, has previously publicly detailed that physical abuse she suffered, remained romantically involved with Mr. Combs on and off until less than a month before victim 1 filed her November 2023 lawsuit. I sent Mr. 𝐷𝐼ITG and our investigator the following text message, which is redacted. The next day, our client made the call in which the government transcribes redacted. The last part of the sentence, which is not included in the government's brief, but is in the exhibit, states redacted. Ultimately, redacted. On October 7th, 2024, we received the government search warrants affidavits. It became clear to me from redacted that victim 3 was considered an alleged victim by the government and that blank. With this information from the search warrant affidavits, redacted. Therefore, after October 7th, 2024, I have not reviewed any discovery where Mr. Combs states on any calls or any emails to anyone to contact victim 3. Instead, Mr. Combs focuses on potential witnesses to address victim 3 and possible allegations. There was never any instruction whatsoever that Mr. Combs or counsel would blackmail victim 3. Yeah, hit that like button. Hi, Miss Pandora. Good to see you. Thanks for being here. Good to see you too, Gala. Thank you for being here. Okay, let's see. Witness 1. The government's response addresses Mr. Combs' contact with witness 1. Redacted. The search warrant affidavits received on October 7th, 2024 state redacted. Redacted again, who the government describes as witness 1 in document number 69. Prior to reviewing the government search warrants, I was unaware that the government put witness 1 in the grand jury redacted. How the hell are we supposed to even follow with all these redactions? Girl. Anyways, let's move on. I first learned of witness 1 redacted when Mark 𝐷𝐼ITG and I were in Miami, Florida, meeting with our client at his house. As part of defense investigation, we have discussed several individuals with whom Mr. 𝐷𝐼ITG and I determined we should interview as part of our defense investigation. Redacted. The photograph below, redacted. Are you surprised? Sean P. Diddy, Puff Daddy, whatever his name is wild. On June 25th, 2024, Mr. 𝐷𝐼ITG and I traveled to redacted to continue our investigation. Mr. 𝐷𝐼ITG and I met with Mr. Combs at his home in Los Angeles. Mr. Combs called witness 1 at redacted. Mr. Combs made this phone call in our presence, and then there's a whole paragraph redacted. I memorialized this conversation in writing at the time. On June 27, 2024, after redacted, Mr. 𝐻𝐿𝐴 and I redacted. On July 8, 2024, I believed I contacted witness 1 for his attorney's name and contact information. Mr. 𝐻𝐿𝐴 and I spoke to witness 1 attorney who declined to make his client available for interview. The individual, as the government states, is Mr. 𝐁𝐮𝐲 redacted. The government writes that Mr. 𝐁𝐮𝐲 said he has redacted. This has nothing to do with redacted. He goes on to talk about redacted. There's no indication in this call or any others that I've received in discovery and listened to that he wanted to distribute redacted or videos of victim 1 to the media. Instead, he says redacted. Mr. 𝐁𝐮𝐲 says next redacted. Here, Mr. 𝐁𝐮𝐲 is referencing to an unreleased video of a song called Stay, Part 1 from his September 2023 album called The Love Album. He stated redacted, but redacted. It is my understanding that redacted, dropping songs and music videos anonymously is regular practice in the music industry. It is also my understanding that the music video for the song was never redacted. I reviewed this music video on the evening of November 20th, 2024, and can confirm that this music video does not reference victim 1. So there's an unreleased music video that they were trying to say had victim 1 in it, which is 𝗂𝐴𝐶𝐵HI, I believe. Because individual 1 is Mr. 𝐁𝐿𝐴's longtime videographer, I asked him to provide me with all the videos he had access to of victim 1, as these videos are responsive to request in the corporate record subpoena. He provided me with these videos on October 29, 2024. I produced 13 videos regarding victim 1, some depicting her and 1 depicting my client regarding her, to the government as part of our rolling subpoena compliance. On November 12, 2024, individual 1 contacted me and stated that the lead case agent approached him and that they were going to meet the next day. I instructed my client immediately to cease contact with individual 1. BOP prison calls. Hey, big girl for life. Good to see you. Thanks for being here. We're just reviewing the past week's Diddy documents. Thanks for being here. It is my understanding that BOP inmates receive 300 minutes of phone calls per month, with an additional 100 minutes per month in November and December. It is also my understanding and my experience based on phone calls with my client that calls are limited to 15 minutes in duration and that the phone system allows inmates to make 1 call per hour. As I understand it, inmates will frequently use other inmates' minutes to allow for more than 1 call in 1 hour period and more phone calls once the 300 minutes expires. After Mr. 𝐁𝐮𝐲 was incarcerated, the government advised me that they were aware of many contraband cellular devices in the MDC and asked if I would change Mr. 𝐁𝐿𝐴's iCloud passwords. I agreed. To date, I have been unable to do so, but have represented to the prosecutors that Mr. 𝐁𝐿𝐴 does not, nor does he use a contraband cellular device. ContactMeASAP.com and prison calls have been monitored, recorded, and reviewed by SIS officers at the MDC. These communications have subsequently been produced to the government. Since Mr. 𝐁𝐿𝐴 has been incarcerated, I have been aware of his use of ContactMeASAP.com, although I did not have an understanding that this was unauthorized. I have spoken multiple times with an administrator of the website and confirmed that this method of communication utilized by the Bureau of Prisons' TrueLink's core link system was monitored by BOP officials who are able to monitor every message Mr. 𝐁𝐿𝐴 sends and receives. My understanding has now been verified through the government's discovery because we have received Mr. 𝐁𝐿𝐴's contact me ASAP messages. The government never instructed me to refrain from having him use the service, nor has the BOP. Mr. 𝐁𝐿𝐴 is no longer using contact me ASAP as of November 16th. On November 13, 2024, the government produced their 6th production of discovery to the defense. Included in this production was redacted from the Intercontinental Hotel incident in March of 2016. Attached to the declaration is Exhibit B and C. On November 15th, I asked the government when they came into possession of redacted. The government replied that they came into possession of redacted on August 7th, 2024. On November 15, 2024, we retained 𝐷𝐿 as an expert. In connection with his retention on this matter, we provided him with the protective order entered in this case, Exhibit 1, from the government's previous bail findings produced to us in discovery on November 13, 2024. At my counsel's direction, Mr. McCourt created this video, attached this declaration as Exhibit D, comparing Exhibit A and the government's bail response with Exhibit B. Pursuant to 1746, I declare under penalty of perjury that the foregoing is true and correct. And that was from Tony Rose Garagos, which was another attorney, I believe, that Diddy has on his team. I think it's hilarious how he keeps trying to get bail. Yeah, it's his third time, man. I mean, wow. Okay, so now we're going to read document 82. And this is just one page. And this is to the judge from Diddy's team again. They're really working over there, huh? 𝗏𝐿𝐿 must be making some bank. Dear Judge Submarinian, in support of Mr. Combs' renewed application and its reply, we have submitted to the court and the government a 20-minute video under seal pursuant to the protective order in this case. The video was prepared by Mr. Connor McCourt. Mr. McCourt was previously a foot patrol officer with the New York City Police Department in January of 1993 and was promoted to sergeant in November of 1997. And after September 11th, he was assigned to the Technical Assistance Response Unit. 𝗟𝗏 was a unit that supported detectives and investigators in the field for high-level crimes. Within 𝗟𝗏, he helped develop the forensic video subgroup at 𝗟𝗏, which focused on recovering video from crime scenes where there were homicides, kidnappings, and police-involved shootings. While at 𝗟𝗏, Mr. McCourt performed thousands of forensic video analysis and would process the video for detectives for the district attorney's office. Mr. McCourt completed his career with the department in 2009. After retirement from the department, he started McCourt Video Analysis, where he provides analysis of video for legal cases. In that capacity, he also provides services for several district attorneys' offices and public defense attorneys' offices. He is available to testify at Friday's hearing if the court would like to hear his testimony as to Exhibit D and its underlying exhibits. We would need sufficient advance notice for him to bring his electronic equipment to connect and to provide a court-provided screen in the courtroom to allow for testimony. We anticipate his direct testimony in the court, if the court wished to hear it, would be less than 40 minutes long. Signed by Mark Agnifilo. 11/21 as well. So they have a video analysis specialist. Hey, Prime. Good to see you. Thanks for being here. Oh no. Oh yeah. Okay. I'm like, I lost track. Not the short-term memory. Okay. Document 83. Again. This is document 83, filed 11/22 by Diddy's lawyers. He needs to get. I'm tired of hearing shit. I know. We're all diddied out. Y'all have to hang in there. Hang in there. We got each other. Hugs. Less than 40 minutes. I know, right? Yeah. Okay. I've been reading. If you guys missed my live earlier, I read through some other documents. So yeah. Okay. We have one more to go. And this one is, no, oh yeah, I already said it, right? Not me repeating myself. Document 83, November 22nd. The government respectfully submits this letter in advance for the hearing scheduled on November 22nd in connection with the defendant's renewed motion for bail and its response to the court's inquiry about the relevance of the bail package ordered with the government's consent as to defendant Michael Jeffries. For this reason, stated below, the circumstances in Jeffries are inapposite and provide no support for the defendant's bail application in the instant matter. On October 17, 2024, a grand jury sitting in the Eastern District of New York returned an indictment charging 3 defendants, including Jeffries, with 1 count of trafficking and 15 counts of interstate prostitution in violation of Code 2422, because we need the codes. As alleged from approximately 2008 to 2015, Jeffries and his co-defendants operated an international sex trafficking and prostitution business. Jeffries allegedly paid for dozens of men to travel within the United States and internationally to meet Jeffries and his co-defendants to engage in commercial sex acts. In addition, Jeffries and his co-defendants relied on a security company to surveil and intimidate witnesses who threatened to expose their misconduct. Following his arrest, the government consented to Jeffries' release on strict bail conditions, including a secure $10 million bond and home detention with electronic monitoring. So I will be covering that document tomorrow because I have not read through it. It's pretty lengthy, but if this guy is out on $10 million bond and Diddy offered 50, I mean, you guys think this guy should have been left out on bond? Therefore, does Diddy have that same prerogative? Yeah. Thank you, life artist. Let's continue. The defense argues in its renewed bail motion that Combs is similarly situated to Jeffries and should similarly be released. But beyond superficial similarities, the high-profile positions of the defendant and sex trafficking charges, the cases are materially different as multiple factors the court must consider under the Bail Reform Act. First, the nature and circumstances of the offenses are substantially different. While the Jeffries case alleges the use of force, fraud, and coercion to engage men in non-consensual sex, there are no allegations that Jeffries committed non-trafficking related violent acts or that he used firearms during the charge period. The indictment against Combs alleges both. With respect to the charged offenses, Jeffries does not include a racketeering offense. By contrast, Combs is charged with a leading racketeering enterprise that engaged in a persistent pattern of racketeering from 2008 to 2024 that included repeated acts of violence by Combs and his co-conspirators, including multiple acts involving kidnapping, arson, and forced labor. Further, as detailed in the indictment, Combs protected and promoted his role in the enterprise through violence, use of firearms, threats, coercion, verbal and emotional, physical, and essay. As recently as March 2024, firearms and ammunition, including 3 AR-15s with defaced serial numbers, were recovered from Combs' residences. Second, the defendant's criminal conduct, including acts of obstruction, has persisted through the present. While Jeffrey allegedly also engaged in efforts to conceal criminal activity, including through the use of surveillance and threats of litigation to ensure victims' silence, that alleged conduct ended in 2015. Here, however, the conduct charge against Combs extends through 2024. And even since being charged, Combs has continued his obstructive conduct, including by repeatedly flouting the orders of the court and the rules and regulations of the BOP. For all the reasons cited in the government's opposition, it strains credulity to believe that Combs will stop engaging in criminal conduct and abide by conditions of release. Third, the history and characteristics of two defendants are significantly different. Jeffries is 80 years old with no criminal history. Combs is decades younger. Further, he has been arrested and investigated multiple times for crimes of violence and obstruction, and as described above, has repeatedly violated BOP regulations and the very same gag order that he demanded that this court enter. In sum, Jeffries is materially different from the instant matter. For the reasons stated above and in the government's motion, the defendant's renewed motion for bail shall be denied. They're like, don't compare yourself to Abercrombie CEO. That was document 83. These are wild. I hadn't read through these. Yes, Carrie. I do think Aaron Carter was silenced. I do believe that plays a role. But that's just my opinion. I am just little old me doing little old YouTube. So it's just opinion. But yeah, I believe a lot of artists have been victims of Diddy, including Aaliyah. Justice for Aaliyah, Pac, Biggie. Where is Blue Cantrell? Can someone call her up and tell her, like, hey, we need to hear from you? Because she was Jay-Z's girlfriend and person that took over Aaliyah's position in the whole Rock Nation thing. But if you know, you know. We're going to be covering that here soon too. So make sure you turn on that notification bell so you don't miss my lives. Anyways, let's continue. Last document. Document 84, filed 11/22. To the judge. Thank you, Sarah. Yes, it's unsettling how much potentially will be uncovered. Yeah, and if you guys don't know about the Brittany Murphy stuff, stay tuned. I believe that also plays a big role here. Okay, last document. Dear Judge Submarinian, we submit this letter in further support of Mr. Combs' renewed motion for bond with the accompanying exhibit, which is a letter to the government sent to us at 11:32 p.m. yesterday. This letter was sent to us in response to targeted Brady request. The proffer cited in the government's letter further support Mr. Combs' position as to the weight of the evidence and the nature or seriousness of the offense. As just one example, in attempting to refute the defense's proffer during the initial Bell hearing, the government argued the following. Yesterday, the defense said they interviewed about half a dozen escorts who would dispute the government's account of what happened during freak-offs. Our investigation is ongoing, so I cannot say too much about this, but I will note that half a dozen escorts is just the tip of the iceberg of the number of escorts who have participated in freak-offs. And that was on September 18, 2024. As the government's Brady's disclosure makes clear, however, redacted. Additionally, this letter provides even more new information that warrants reopening the Bell proceedings. Defense counsel will address these points at the Bell hearing today. Although we do not believe there's any basis to seal the government's letter, we have not had an opportunity to confer with the government on this issue and are filing under seal in the first instance in the abundance of caution. So basically what Diddy's defense attorney is asking for here is for them to go back to the beginning. So now they're going to start all over, and they want to say that something went wrong in those first Bell hearings, etc., and that the government mentioned something about escorts. So therefore, now they're wanting to go back and probably go through everything again to make sure that I don't know, that the diddler is innocent, I guess. That was document 84, and we are done. That is everything filed in the New York docket as of November 22nd. I know that he had the Bell hearing, and we're waiting on Monday to see what happens. Yay, Augie, I appreciate you so much, my love. You're such a big supporter of the channel. Does not go unnoticed. I love you very much. Yay, did Carrie get it? Yay. Yay, welcome, Carrie, to Mellyverse. I'm working on a few things for members, so it's a little more personal, a little more intimate, but it'll be fun. So, okay, we did it. We got through it. We read through 70 through 84 of the Diddy documents. You can say you officially read the legal docs with me. I appreciate you guys all for being here, and I know it's a lot of reading. I plan to do another live in a minute. No reading. That'll just be like more fun. But I appreciate you guys. Make sure you hit that like button and make sure you're subscribed. Turn on your notifications. Exactly, Gary. Mellyverse Minion official. Thank you again, Augie, for gifting. And you gifted in the last live too. So if you guys missed my previous live just an hour ago, it was the Kansas mom. And I will be back later to cover a trial. There's 2 trials that I want to cover. So I'm going to start by covering those. I do want to cover Boone trial. I know some of you have probably already seen it, but I missed it because I was covering Simon, Leilani Simon. So I do want to cover that. So it'll just be like a hangout thing, but that's not the one I want to cover tonight. So I will be back later either with trial coverage or another live. So yes, Sarah, thank you. This is such an amazing community. Yeah. Well, I'm not done life artist. I'll be back. And like I said earlier, there's some cases local to me and other ones that I've not talked about on YouTube. I have already done my research that are really good. And I'm just waiting to hear back on a couple of district attorneys. I got a couple autopsies. So let me just put those together, and those should be done by the end of tomorrow, hopefully. So hopefully I have new content that is not on YouTube for you guys to enjoy. And I've been working really hard on it. So I'm really excited about that. In cases that are not known of. So tomorrow I will be covering one of those, I believe. But anyways, I'm ranting. I'm just going off. We haven't done a Melly After Dark in a long time. I'm thinking about bringing those back. You know, there's just a lot of controversy, but it is what it is. First Amendment rights, right? I can speak of whatever the hell I want on my channel. Yeah, come back. I'll be back later tonight. If not, probably most likely I will be back in like an hour, and then I'll also be live tomorrow. So make sure I see you guys. Savannah, in order to handle the sentencing. Yeah, I agree, Carrie. And I appreciate you, Life Artist, all of you, Carrie, Dragonfly, Augie, all the mods, Sarah, Life Artist. I know Debbie popped in earlier. Appreciate you guys all for stopping by. Johnny, all of you. Hi, Juicer. Good to see you. We're just ending the Diddy live, but we'll be back with another one shortly. Love you, Augie. And I love you guys all. Make sure you hit that like button on the way out. And I will see you guys shortly for another live if you're around. Bye.